question that people may want to ask. Equally, if you want to ask any questions as we're going through on the chat, then please feel free to do so. I'm not sure if we've been joined by everyone, but I think as it's just gone 5 o'clock now, I think that we'll begin. All right, so I'm now going to share my screen and begin the webinar, which, as you can see, is, as I've just said, vulnerable witnesses, family proceedings, are we doing enough? And can I say at the outset that when I was thinking about what webinar to produce, the reason I decided that vulnerable witnesses was a topic that I felt was worth doing was because I sit both in the family court and in the Crown Court, and I see very frequently the different approaches that actually are still taking place. And I'm also seeing, sadly, many of the continuing inadequacies in both jurisdictions. I'm also aware that the FLBA is currently hoping to roll out a training system, a training course, and that's not only for practitioners but also for judges, but there's an awful lot of judges that still haven't attended. As we go through this, you'll see some of the concerns that I'm highlighting. So if we can just move on to the next page, which at the moment isn't operating, so just bear with me a moment. Right. So let's go back to, so the first page is the historical summary, and I thought that it would be interesting to begin by looking at, in fact, where we were and where we've come from in relation to vulnerable witnesses. And of course, it seemed to me sensible to begin with looking at the essential elements of our justice system, which of course we're all very familiar with, and that is access to justice, just procedures, and fair hearings. And I think it's always important to bear in mind that the justice system needs to enable best evidence by all its participants. And the operative word of enable is precisely what we should be doing with vulnerable witnesses who do have difficulties in presenting evidence. We go back to the Speaking Up for Justice report, really, in June 1998, which really is the first formal report that addressed the treatment of vulnerable or intimidated witnesses in the criminal justice system. It provided recommendations to support and assist vulnerable or intimidated witnesses, and Part 2 of the Youth Justice and Criminal Evidence Act 1999 implemented those parts that required legislation, which, as we know, has now been amended by the Coroners and Justice Act of 2009. The key recommendations at that time in that report were improvements in the identification of vulnerable or intimidated witnesses, greater communication within the criminal justice system about the needs of a witness, including consultation between the police and the Crown on what special measures would assist a witness, and a pre-trial meeting between the Crown and witness. It also looked at the use of appropriate interview methods and pre-trial support, including the preparation of witnesses for court. And just pausing there, vulnerable witnesses does include vulnerable defendants, although I can say that even today, there does still remain a distinction between the special measures that are available for both. The report also recommended a range of special measures available for the use at the trial. And these included video recorded statements to replace the evidence in chief. And in fact, we will have seen this in the family division. In fact, this had first been recommended by the Memorandum of Good Practice for Video Recorded Interviews with Child Witnesses, Home Office 1992. But by the time of this report, in '98 was still not being fully implemented. We then know the Achieving Best Evidence was subsequently published in 2002, and for those of you who may be interested to know, this has been recently updated this year on the 31st of January. It also provided for video recorded pre-trial cross-examination, and the rollout for this did not begin until 2014, which was some 15 years after the report was first published, and I can tell you is still not in full operation. It also provided for live TV links and screens around the witness box, so the witness did not need to face the defendant in court. It provided for the removal of wigs and gowns, and just pausing there because I always am reminded when I get to that point of approaching a silk who was representing a child in the Old Bailey who was a witness in relation to a case that I was representing a defendant, but the child was a witness. And the judge decided that I could sit with this child who was going to give evidence over a video link. And all was going well in the preparation of that as we moved towards the room until I actually suggested to the silk, female silk, that I wondered if she would care to remove her wig, and furthermore, whether she would be kind enough to ask the judges to remove their wig. And I say judges, although it was at the Old Bailey, we were actually on an appeal and we had to go to the Old Bailey so that we could have a video link, as there wasn't one at that time in the High Court. If I tell you her reaction to me when I suggested she should remove her wigs, and the judges should also, I don't think could have been more surprised than if I'd asked her to remove her entire clothing. It clearly was a very big issue for her and the judges also, but that was some years ago, and thankfully we have moved on considerably. The report also recommended assistance with communication if necessary, including the use of an intermediary, and the power for the judge to clear the public gallery in cases involving sexual offences or intimidation, so the witness could give evidence in private, and which obviously in the criminal courts was an extremely new approach. There was the discretionary reporting restriction for witnesses who were intimidated, and a discretionary ban on the defendant cross-examining in person. And this was in cases other than sexual offences where a mandatory ban had already been implemented. And again, that's the Youth, Justice and Criminal Evidence Act 1999, Section 34, and that was implemented on the 4th of September 2000. We then had the provisions of Section 16 of the Youth, Justice and Criminal Evidence Act as amended. And as we can see, all child witnesses other than the accused under the age of 18 were automatically eligible for special measures. Other witnesses may be eligible if the quality of their evidence was likely to be diminished by reason of disorder or disability, and that included mental disorder, significantly impaired due to a learning disability, or if they were suffering from a physical disability. Section 17 of that Act provided for those suffering from fear or distress in giving evidence, and that included complainants of sexual offences automatically qualifying unless they wished to opt out, and also similarly for witnesses to certain offences, including guns and knives. The report introduced the Victims Code. Victims of the most serious crimes might also be regarded as intimidated, and that included by close relatives. And sexual offences, Section 22A of the Act, as amended on application, automatic admissibility of a visually recorded statement as evidence in chief under Section 27. Well, that's a very quick romp through the criminal proceedings, but I hope that that gives some indication, if you like, of where all of this really originated. and certainly the family proceedings courts until now have really lagged behind. And that was recognised by our then president in 2014, Sir James Mumby, who noted the issues faced by vulnerable witnesses and parties in the family courts and stated that family was lagging woefully behind criminal law, and he set up a working party. And it is particularly, and this is my comment, surprising that family cases were lagging behind criminal cases when we have regard to Rule 1.1 of the Family Procedure Rules, 210, where the court must deal with cases justly, having regard to any welfare issues involved. Well, what the president at that time said when he spoke to the Wales Observatory was basically this, and quite frankly, in my view, was stating really what was obvious. Children, precisely because they are all children, are vulnerable, but so are many of the adults who come before the family court, whether as parties or witnesses. Vulnerability comes in many forms: physical, mental, and social, to mention but three. Let me give some examples to illustrate the range of the issues which the family court deals with all the time. For many litigants in family cases, English is not their mother tongue. Some are illiterate, some are deaf or blind, or have other physical disabilities. Studies show, as experience suggests, that a significant number of parents involved in care proceedings have often significant learning disabilities. Another kind of vulnerability is exemplified by the victims of actual or anticipated domestic violence, forced marriage, female genital mutilation, or even worse. Can we honestly assert that we are as alert as we should be to the problems and to the imperative need to ensure that the vulnerable who come before us, whether as parties or as witnesses, are enabled to participate as they are entitled to fairly and properly in the proceedings, and not left in a position of disadvantage? Although I should like to think so, the truth is that much more needs to be done. And I can certainly say, and I don't know how some of you have found the courts, but I do still find that some courts have continuing difficulties in necessarily implementing the special measures, or implementing them in, dare I say, a sensitive manner. Now, that's not to say I find that all the time, of course I don't, but I have found it in some cases, and it is a little concerning. Well, following what the then president said, there followed a detailed analysis by the working party, and the family procedure rules were amended to make specific provision for vulnerable parties and witnesses. And here we therefore come now to those amendments, which is the Family Procedure Rules Part 3A and Practice Direction 3AA, which came into effect on the 27th of November 2017. And I should say, and I mentioned this a little bit later as well, that when looking at that rule, or those rules, and the practice direction, you really do need to also work with and look at simultaneously the Advocates Toolkit. Number 13 addresses the family court, and number 10 is also relevant in relation to vulnerability. Looking at that, vulnerability is not defined. So when considering vulnerability of a party or a witness who is not a protected party and pausing there, that's essentially someone suffering from incapacity. Rule 3A.3.1, the court must have regard to the following, and that's provided by Rule 3A.7. So firstly, the impact or any actual or perceived intimidation, including any behaviour towards the party or witness, on the part of any other party or witness or members of the family or associates of that other party or other witness, or any members of the family of the party or witness. And pausing there, I think you can see, having gone through the criminal procedure very quickly, that is now beginning to mirror what the criminal procedure and the criminal rules were implementing initially. The second part is, just going back there, sorry, is whether the party or witness suffers from a mental disorder or otherwise is significantly impaired due to a learning disability, has a physical disability or suffers from a physical disorder, or is undergoing, and that should be mental health treatment. The nature and extent of the information before the court. But not limited to any concerns arising in relation to abuse as defined by the Domestic Abuse Act 2021, and can also include, but not limited to, forced marriage, honour-based violence, dowry-related abuse, and transnational marriage abandonment. It also includes looking at whether a matter is contentious, the age, maturity, and understanding of the party or witness, the social and cultural background and ethnic origins of the party or witness, the domestic circumstances and religious beliefs of the party or witness, any questions which the court is putting or causing to put to a witness in accordance with section 31G6 of the Matrimonial and Family Proceedings Act of 1984, and that relates to the court questioning a witness on behalf of a litigant in person, and any characteristic of the party or witness which is relevant to the participation direction which may be made. So there are, just pausing there, a number of factors that the court can be invited to take into consideration. I say this a little bit later and I say it now, it's really important, if you are going to be making an application for special measures, that you give some very serious thought to the grounds upon which you would want to base that application. And as you can see, there are more than one, or there is more than one, I should say. There's also whether any measure is available to the court, the cost of any available measure, and any other matter set out in Practice Direction 3AA, which I'll come to in just a moment. Now you can see I've put there Toolkit 10. That is identifying vulnerability in witnesses, and Toolkit 13, which, as I said earlier, is directly relevant to the family courts. I should say, and I'm sure most of you have familiarized yourself in any event with the toolkits, but these toolkits are phenomenally directional and phenomenally informative and helpful. They address so many vulnerabilities and explain the difficulties that the various disabilities create for the witness concerned. For example, autism, learning difficulties, and many other mental health illnesses. They really, really are extremely helpful. What I can also say to you is that they are about to all be updated as well. But certainly do familiarize yourself with the toolkit that is relevant to the witness that you're representing or is in the case. And also, as I say, number 10 and 13. So looking then at Practice Direction 3AA, paragraph 3.1 also requires the court to consider the ability of the party or the witness to firstly understand the proceedings and their role in them when in court, to put their views to the court, instruct their representative before, during and after the hearing, and attend the hearing without significant distress. The court should require the assistance of relevant parties in the case when considering whether the participation of any party or witness is likely to be diminished by reason of vulnerability. And as I've said, familiarise yourself with, in particular, those two toolkits. When preparing to question a vulnerable witness, we should all bear in mind that each witness is unique. We should also bear in mind that we all as advocates have a responsibility to assist the court to identify and appropriately respond to the vulnerability of witnesses and parties. And vulnerability is not the same as unreliability. And with the right support, vulnerable witnesses can give reliable evidence. Always remember the expression or the phrase that Lady Hallett came out with in relation to the criminal case of La Bomba and subsequently the Crown against JP. Advocates must adapt to the witness, not the other way round. Remember, vulnerabilities come in various guises, and remember to identify a client's vulnerabilities at an early stage. And I've put this into this webinar because I think that when we first meet with clients, that's really when we should be addressing the question of vulnerability and how best we can assist them in the event that the case does go to court. Bearing in mind, some clients may not want to appear vulnerable, and so asking routine questions such as whether they're in receipt of disability allowance or PIPs would be a really good indicator, because clearly if someone is in receipt of either of those, there is inevitably a vulnerability. Equally, asking a client if they are disabled may not provide an accurate response, but general questions about their day-to-day routines may do so. For example, do they have a social worker? Do they or did they get special help at school? Have they used the mental health services? Do they need help filling in a form, managing money, getting to appointments? All of those are sensitive questions, which can be extremely enlightening. And just to explain the caption, or the picture, I should say, at the top right hand of that page, these are stress toys. And I say that to a number of people when I'm sitting in court, particularly in the Crown Court, and I'm often received with some degree of bemusement because they're not really sure what I'm talking about. At the end of the day, stress toys are enormously helpful for vulnerable witnesses, and they come in all sorts of shapes and sizes and materials and so on. Some vulnerable witnesses benefit from something that they can literally keep squeezing, others that they can keep stretching, others that they can click. It's something to do with their hands, and it's something that the courts and certainly intermediaries should literally have to hand in order to assist vulnerable witnesses. But I find time and time again, neither the courts nor intermediaries nor victim support bring anything like this with them when they are accompanying a vulnerable witness. And so what I've tended to do is to order my own box of stress toys from Amazon. Forgive the advertisement, but I can tell you that you can get a very good selection for $19.99, keep them in your office and offer them to someone if you think that they may be vulnerable. If they say they don't need them, that's fine. But I have to tell you, certainly my experience is when they've been offered, they have been very gratefully received. I also suggest that they should be made available for the witness at court And as the court is unlikely to have anything like this, then again, you may wish to take them with you if the witness is indeed your client. The other thing I've said about preparing to question is observe their behaviour and their body language and their presentation. One obvious sign of autism is the inability to look someone in the eye. Now, that doesn't mean to say people that can't look you in the eye are all suffering from autism. Of course it doesn't, but it's an indicator. Again, I say familiarise yourself with the toolkit. Forgive me for repeating that, but they are really, really helpful. Also, ask the client what they think might assist them in giving evidence. Would a client feel better able to give evidence in the morning or the afternoon? Something that a lot of us actually don't really think about, and why should we, if we don't have experience of someone who perhaps is suffering from a mental health disorder. I guarantee you that people suffering from mental health disorders, and certainly serious mental health disorders, almost always suffer at some time from a sleep disorder, meaning that they cannot sleep at night, or they have restless nights, or they're having post-traumatic stress, panic attacks at night. And therefore, they often will sleep in during the day. And therefore, if they are going to be giving evidence, the morning is not necessarily going to be the right time for them. And I pause because I can hear perhaps some of you thinking, well, I can't imagine if I say to a judge that my client has to have a lie-in every morning, that they're necessarily going to accommodate them by shifting the evidence around to the afternoon. But this really is an important factor. And going back to the very beginning, this is all about enabling people to give evidence, enabling them and facilitating them to give the best evidence possible. And when you think, and indeed when I direct a jury about vulnerable witnesses, when they're giving evidence behind screens or they're giving evidence over a video link, I always emphasize that this is simply to enable them to provide the best evidence they are able to do. And that's what it's all about. So judges do need to be told about these issues, and hopefully most of them will be receptive. Another question to ask, of course, is, are they on medication? And if so, how does that affect them? And of course, medication can be very telling, because it can make a witness very sleepy. It can make them calm down. For example, if someone is suffering from ADHD, you need to know when they take their medication, how long it takes for it to work, because the last thing that they would want, I'm sure, is to be giving evidence from a witness box when unfortunately their mind is racing, which often happens with ADHD. And as I've said, would they benefit from having a stress toy? Expert advice may be necessary to establish vulnerability, for example, from a psychologist or a psychiatrist. An intermediary, of course, is not an expert witness, but can assist by assessing communication needs and abilities of witnesses. Most importantly, as I said at the beginning of this section, remember the rules do not define vulnerability, but provide a list of considerations which are to be taken into account when considering the vulnerability of a party or witness. I've referred you back to slides 10 to 13. Moving on then to look at participation in proceedings by a vulnerable party. Rule 3A.4 places a duty on the court to consider whether a party's participation in the proceedings is likely to be diminished by reason of vulnerability, and if so, what is necessary to make one or more participation directions. So of course, we're now moving on to look at special measures. This rule does not apply to a child or protected party who lacks capacity, and it requires the court to consider making directions to enable a vulnerable party to fairly participate in the proceedings. And this is distinct from the court's duty to consider impact of the party's vulnerability on their ability to give evidence. Note the decision of Re C and Re A, 213 and 214 decisions. Advocates need to be alert. They have a duty to alert the court at the earliest opportunity if a client has a hearing or learning disability, and regarding the role of expert evidence in such cases. Remember, as I said, a protected party lacks capacity under the Mental Health or the Mental Capacity Act of 2015. And just looking at that for a moment, Rule 3A.6, the court must decide whether necessary to make participation directions to assist the protected party to participate in proceedings, or the protected party giving evidence. So it's not just about giving evidence from the witness box, it's about participating as well. It also looks at the views of the litigation friend required before participation directions are made, and the court must consider making participation directions for protected parties. Practice Direction 15B is the practice direction that you need to look at in this particular instance. 1.4, the court may have to determine whether a protected person can give evidence and whether special measures are required. Expert evidence is also required, but the court may accept evidence from a treating clinician. The impact of giving evidence may need to be considered by the court, and whether it is so adverse it's not in the party's interests to give evidence. And I'm going to expand on that just a little bit later, because that doesn't just apply to protected parties. Note, if a protected party is to give evidence, the court must hold a ground rules hearing. And then looking at generally participation in proceedings by a vulnerable witness. Rule 3A.5, this rule places a duty on the court to consider how a party or witness can give evidence. Two factors to be considered by the court: whether the quality of evidence, and that relates to coherence and accuracy, is likely to be diminished by reason of vulnerability, and if so, whether it's necessary to make one or more participation directions. And ahead of any participation directions being made, the court must consider any views by the party or the witness. And note, the duty does extend to children witnesses. And note, in deciding whether a child should be giving evidence, the court must apply the relevant case law and guidance from the Family Justice Council. So looking now at the test to be applied in determining whether children should give evidence in family proceedings, it's common ground, I'm sure we all know, that the test to be applied is found in Re W, Children Abuse Oral Evidence 210, Supreme Court decision, and can be summarised as follows. And just before I get there, it's been reinforced in the decision of Re R, Children 2015. So essentially, what we have to look at is the fair balance between Article 6 rights and Article 8 rights of the perceived victim may mean that in care proceedings, the child should not be called to give evidence, but that outcome, i.e. that a child should not give evidence, is as a result of the balancing exercise, and it's not a presumption or even a starting point. Secondly, the essential test is whether justice can be done without further questioning of the child. And thirdly, the court weighs two considerations. Firstly, the advantages that the child giving evidence will bring to the determination of the truth. And secondly, the damage giving evidence may do to the welfare of this or any other child. Looking then at participation directions, the purpose is to assist with the giving of evidence or participation in proceedings, and to invoke one or more special measures listed in Rule 3A.8. So when looking at when to make an application for a participation direction, which we all refer to in practice as special measures, the procedure is that it should be made as soon as possible in the process. It can be made at any hearing by effectively any party or of the court's own motion. And as part of the court's considerations, it must consider the availability of the special measure and the cost. Now, there's no exhaustive list provided by Rule 38.1 of what participation directions can be made, but these are examples: to prevent a party or witness from seeing another party or witness, to allow a party or witness to participate in hearings and give evidence by live link, to provide for a party or witness to use a device to help communicate, to participate in proceedings with the assistance of an intermediary, to be questioned in court with the assistance of an intermediary, or do anything else which again is set out in Practice Direction 3AA. And looking at Practice Direction 3AA, it is the duty of the court and of all parties to the proceedings to identify any party or witness who is a vulnerable person at the earliest possible stage of the proceedings. All parties and their representatives are required to work with the court and each other to ensure that each party or witness can participate in proceedings without the quality of their evidence being diminished and without being put in fear or distress by reason of their vulnerability as defined with reference to the circumstances of each person and to the nature of the proceedings. Now, to some extent, I think we can probably all think, well, that's fairly obvious. We are all advocates, we have duties to the court, we have duties to our client, and we should all be working together. I don't know what some of your experiences has been, but in a recent case that took almost 3 years to conclude, going through the various stages of the proceedings in the High Court, I can tell you that a very senior silk struggled with 1.4 in relation to my client, who was a mental health patient whose capacity fluctuated. And I can tell you that we had some very lively exchanges in relation to what he could and couldn't do during the course of this process when cross-examining my client. And if there's time or a time on another occasion, I will update you in relation to that. Ground rules hearings then, I think that's the next important thing we need to consider. When should this be held? The court must hold a ground rules hearing prior to the hearing, but need not be separate to any other hearing. So it can be part of a case management hearing. It doesn't have to be listed separately, but it should be prior to the hearing. I can tell you that we had a ground rules hearing on one occasion in a family court a few years ago, which took something like 4.5 hours with a child witness waiting to give evidence. And that was a very, very bad experience for that child. What's its purpose? Well, it's to decide participation directions. It's to decide in what manner vulnerable witnesses should give evidence, best way for vulnerable witness to give evidence before the hearing, transcript or oral, cross-examination, what participation directions, and the manner, going back to my infamous silk I just told you about, the manner of cross-examination. When considering cross-examination, the court must consider whether to direct no repeat questions by any advocate. Questions or topics should be agreed prior to the hearing. Questioning of vulnerable witnesses should be by one legal representative or by the judge, and the taking of evidence should be managed in any other way. And just looking at that for a moment, the taking of evidence in some other way, I just wanted to just very briefly remind you of two decisions. One was in the criminal jurisdiction, one was in the family jurisdiction, but they are not dissimilar. In, as I mentioned earlier, Lumumba in 2014, much to the consternation of the criminal bar, I believe, the court decided that in some instances, it wasn't even necessary to put the defendant's case to the complainant. Basically, restrictions could be imposed on putting the defense case, or looked at from another view, the defense may be relieved of their duty to put their case. Inconsistencies in the witnesses' accounts may be pointed out to the jury rather than during cross-examination, but such inconsistencies should be true inconsistencies and should not be trivial. And pausing there for one moment, as I say, that met with considerable consternation from the criminal bar, because we've all been trained to believe we have to put our client's case. In my experience, on those very rare occasions when a case isn't put, and it would usually be for perhaps very young children, I have heard closing speeches, and make no mistake, in my experience, almost always cases are won and lost by closing speeches. I have heard closing speeches where what has been said, because they haven't been able to put their case, has been extremely influential in juries acquitting defendants. So on the face of it, it may seem unjust. In practice, I actually think if it's handled properly and professionally, it isn't a disservice to the defendant. I know I may be challenged about that, but that's just something to throw out there. So far as family law is concerned, Re J, Vulnerable Witness Sexual Abuse Fact Finding 2014, this was originally a case by Mrs. Justice Porfley. It involves sexual abuse findings at first instance, which were set aside by the Court of Appeal. And Lord Justice McFarlane considered the approach of the court to the child's evidence. And I'm watching the time. I'm happy to take you through this, although you can read this, but if I just summarize it by essentially explaining that Mrs. Justice Porfley in the initial hearing was of the view that the young person who was highly vulnerable had to give evidence. And the evidence that she gave was so disjointed, there were so many breaks, she broke down so many occasions that it was felt it was just unreliable. And when it came to the Court of Appeal, essentially Lord Justice McFarlane was of the view that this was one of those cases where actually she should not have given evidence. And obviously it is a balancing act that one has to perform in coming to that conclusion. But what he said was, where special measures have been deployed, it is, however, necessary for the judge who is evaluating the resulting evidence to assess the degree, if any, to which the process may have affected the ability of the court to rely upon the witness's evidence. Where, for example, the witness has simply been unable to play any active part, the court will be required to fall back upon hearsay records of what have been said outside the court context on earlier occasions and without any challenge through questioning. And as I've said, this was a complex case. Of particular relevance in the context of this paper is the conclusion that the judicial analysis should have included assessment of the impact of the necessarily limited forensic process around the vulnerable witness's oral evidence. And the Court of Appeal decided no retrial was to be ordered. He said, it seems highly unlikely that X will be able to engage in a greater extent in the forensic process than she did before Mrs. Justice Porfley. And so effectively, it was found that to have a retrial would be abusive and or untenable. I've thrown in very briefly here, and I'm just going to touch upon this very quickly. Lady Justice Gloucester was also part of that decision. And very, very briefly, in paragraph 109 of the judgment, she was in many ways comparing the criminal jurisdiction and the need for a client to have Article 6 fair trial when looking at the approach of vulnerable witnesses. And I found that a little interesting because she was also in the or on the tribunal in the Court of Appeal in an appeal that we did in 2018 that was successful, because she also referred back to her criminal jurisdiction experience. And in that particular case, although it was on a completely different point, she was expressing her concern about the difficulty in understanding how a judge could evaluate past conduct and future risk other than by applying the relevant criminal standards. And some of you may be familiar now with this case, which was most recently reported in the domestic abuse case, Re H&N, earlier this year, where Lord Justice McFarlane was very, very clear that the criminal concepts should not apply in the family courts. Well, I think Lady Justice Gloucester wasn't entirely with him on that, but nonetheless, she was in the minority, and so that is the law as it stands. We then had the 2017 case, forgive me if I pronounce this incorrectly, but Carmarthenshire CC against Y. A vulnerable adult witness was unable to give evidence, there being expert evidence that it would be harmful for her to do so. And again, the court determined that the case would be decided on other available evidence. Also, at the ground rules hearing, the court must also consider whether the vulnerable witness has previously given evidence, been cross-examined in criminal proceedings, and whether it's been pre-recorded. That's sections 27 and 28 of the Youth Justice Criminal Evidence Act, and given an interview which has been recorded. And again, just going through that quite quickly, ultimately, if there is in existence any pre-recorded interviews or evidence, then the court should consider, in fact, relying on that as the examination in chief. Looking then at intermediaries, part 3A, broadly, the purpose is to mutually facilitate communication and understanding. It can be recommended, the intermediary can be recommended by an expert, but it's not necessary for the court to appoint an expert. It's good practice for an intermediary to attend ground rules hearing, although ultimately it's the judge that makes, obviously, the decisions. For those of you who may find this interesting, HMCTS guidance provides for HMCT to fund where no other funding is available. And I thought this might be helpful for some of you, that funding is also available from the HMCT for preparatory work directly relevant to matters to be dealt with in the courtroom, but outside of courts. In other words, preparing your case, providing you get a judicial order to that effect. And for those of us that struggle in getting prior authority from the legal aid agency, it's as well to remember this, because this provision does exist, but you must get a court order to that effect. Private law children cases involving allegations of abuse. Now, this is where we turn to specific difficulties arising when the alleged perpetrator is the litigant in person. And again, I've turned to a decision of Lord Justice McFarlane, re J218, where he identified there were 3 options available: cross-examination by the alleged perpetrator, granting rights of audience to a Mackenzie friend, and questions to be put by the judge. In 2018, this was actually reviewed, and what was determined was this: where in any proceedings in the family court, it appears to the court that any party who is not legally represented is unable to examine or cross-examine a witness effectively, the court is to ascertain from that party the matters about which the witness may be able to depose or on which they want to cross-examine, and put or cause to be put such questions in the interests of that party as may appear to the court to be proper. But the judge then went on to extrapolate some general principles from which assistance can be derived. And this is quite helpful because going forward, a lot of this is now coming in force. So he said, I propose to make a few observations. I emphasize I do not intend what I say below to be elevated to the status of guidance. There can be no guidance where the situation as here is untenable until Parliament addresses these circumstances. The best I can offer, and I love this expression, is the forensic life belt until a rescue craft arrives. And he then went through what he saw as necessary. So once it becomes clear to the court it's required to hear a case put to a key factual witness where the allegations are serious and intimate, where the witnesses are themselves the accused and accuser, a ground rules hearing will always be necessary. So that's the first thing. And I have to say, I think the family court tends to be, in my experience, a little better than some of the Crown courts on this. The ground rules should, in most cases, be conducted prior to the hearing. Judicial continuity, well, that's obvious, it would be helpful. And it must be borne in mind throughout. The accuser bears the burden of establishing the truth of the allegations, and the investigative process in the courtroom, however painful, must ensure fairness to both sides. And the judge must remind himself at all stages this obligation may not be compromised in response to a witness's distress. But I hesitate to pause there. Of course, a witness's distress is one thing, but a witness's distress affecting them to such an extent that they simply cannot take part in the forensic exercise of giving evidence, I think is something else. There's no presumption the individual facing the accusations would automatically be barred from cross-examining the accuser in every case. So we have to bear that in mind. The judge must consider whether the evidence would be likely to be diminished if conducted by the accused and would likely to be improved if a prohibition on direct cross-examination was directed. In the context of a fact-finding hearing where the ethos of the court is investigative, I consider these two factors may be divisible. And when the court forms a view from the available evidence that cross-examination of the alleged victim itself runs the real risk of being abusive if the allegations are established, it should bear in mind the impact of the court process is likely to resonate adversely on the welfare of the subject children. It is axiomatic that acute distress to a carer will have an impact on the children's general well-being. This is an additional factor to those generally in contemplation during a criminal trial. And of course, that is fair. So his view was there is no presumption the individual facing the accusations will automatically be barred. So it was effectively left to the decision of the judge. Where the factual conclusions are likely to have an impact on the arrangements for and welfare of a child, the court should consider joining the child as a party and securing representations. And of course, in that instance, you would have the child's advocate available to cross-examine. If the court has decided cross-examination is not to be permitted by the accused and there is no other available advocate to undertake it, it should require questions to be reduced in writing, and it will assist the process in most cases if grounds of cross-examination are identified under specific headings. And a judge should never feel constrained effectively to put every question the lay party wishes them to do. Cross-examination is inherently dynamic. For it to have forensic rigor, the judge will inevitably have to craft and hone the questions and essentially, again, looking at fairness and whether conventional cross-examination can be undertaken. What is clear from that decision is that the family court currently, there is no prohibition of perpetrators cross-examining their victim. As I just said, it's a matter for the judge. And this is where there is a stark difference with the criminal jurisdiction, because this is to be contrasted with the mandatory ban in respect of sexual offences in the criminal courts implemented 22 years ago. Section 35 also prohibits cross-examination of children by the perpetrator. I've drawn to your attention, there's a pilot scheme, 8th of March 2022. It's been launched by the government. It's called Pathfinder. I've written a short article on this, and it's in a bid to provide greater support to victims of domestic abuse. And the pilot forms part of the government's sweeping reforms to transfer family courts operating as contained in the Domestic Abuse Act 2021 and include a ban on perpetrators being able to cross-examine their victim and preventing them from making further unnecessary applications to court. Now, this pilot scheme is going to last for some 2 years. So we can imagine how long it will take after that if it is going to be put into legislation before we actually have a mandatory ban in the same way the criminal jurisdiction has. And I'm sure you can read effectively what I've said about that. And again, this is also just explaining to you the pilot scheme. It's currently taking place in Bournemouth, Weymouth, Dorset, Carnarvon, Mold, Prestatyn and Wrexham in North Wales, as I said, for up to 2 years. And I've listed there what the court, or rather what the pilot scheme will be looking at. And as I say, for me, one of the most important things is a prohibition on perpetrators cross-examining complainants. Finishing off with questioning a vulnerable witness, best practice, I've just listed here some main points, which I hope you will find helpful if you're not already applying this. Identify the issues, that's obvious, only ask questions which are key to your case. I do emphasise if issues are a matter of record, such as medical records, police records, these could be presented as agreed facts. Time and time again, I urge counsel in the Crown Court to agree facts that could be put to a jury. There is no need for so many witnesses to be called when things are a matter of record, and there's absolutely no need why we can't apply the same process in the family jurisdiction. Pre-draft questions, absolutely necessary, and I don't know how any of you prepare your cross-examination or examination of witnesses. I have been drafting my questions for years and years and years. It's the only way that I can operate. It helps me focus on where I'm going and what I'm doing. But in cases of vulnerable witnesses, it is absolutely essential because you have to have a very steady flow. There's no scope for answering questions from the hip. There just isn't. Rapport, that's really important. And what the guidance really emphasizes is it's for the judge to establish rapport, not for advocates to establish rapport. The guidance effectively says that advocates aren't to take advantage of vulnerable witnesses by effectively lulling them into a false sense of security by developing a rapport with them. I don't think many advocates would intentionally do that to a vulnerable witness, but certainly the judge should establish the rapport. Pace questioning, unlike me going at this like a train, do pace your questions to vulnerable witnesses, watch their body language, allow for them to think and effectively slow down. Always try to ask questions in chronological order. It's helpful for vulnerable witnesses, especially for children. And when I say chronological, I don't say, well, do you remember in 2020 you did this, that, or the other? Try and link it, certainly with children, and also with many other vulnerable witnesses, to an event such as their birthday, Christmas, when perhaps they went on holiday somewhere, something like that, that they can relate to rather than giving them facts and figures. Always signpost. I mean, I think we should do that with all witnesses in any event, but certainly with vulnerable, always signpost where you're going. So to a child, all right, now, Sally, I'm now going to ask you about when you went to see The Lion King. So introduce what you're going to be asking them about. These are absolute no-nos and you must avoid. Pronouns. If you ever ask a vulnerable witness, did you see him? Did you see her? Did you see them? That can be very confusing for them, and they are likely to give you an incorrect response, just simply to provide a response. Remember questions, again, complete no-no. If you ask them, for example, if they remember telling someone something, the chances are they will remember telling someone, but they may not remember what they told them. So avoid those questions. How and why is particularly difficult for vulnerable witnesses, and particularly people suffering from autism. Leading questions, well, what do we all do in cross-examination? I can remember being pulled up by a judge many years ago who told me off for the way I was asking questions of a psychiatrist. And I pointed out to her that I was cross-examining and I was permitted to do that. Well, with vulnerable witnesses, we are not to ask leading questions because they are vulnerable, they are likely to just go along with you. And that's the last thing the court wants. Tagged questions, out of the question. That's also unnecessarily confusing. Compound questions, the most confusing of all. When you went to see Auntie Sally on the day that it was your birthday, did you see Uncle Jim? Absolutely confusing. Telling someone else something needs to be broken down. So were you thirsty would be a question. Did you tell Auntie Sally you were thirsty? So build it up so that they know where you're going. Finally, I think we are literally on time. Are we doing enough? I've said clearly progress has to be made, but in practice, a judge is entirely familiar with the rules for vulnerable witnesses. Are judges applying the rules? Are legal representatives familiar with the rules and how they're applying them? Does the court have adequate measures, available stress toys? Do we still have some way to go? So I'm going to stop sharing my screen now. And I'm glad to see there are still some people in the audience. I hope that you have found that helpful. If any of you do have any questions at all that you want to ask, then please do feel free to do so. I can see there's, yes, I can see that there aren't any questions, but if anyone does have any questions, please feel free to ask them. No? All right, well, I hope that you have found it helpful, and I will make sure that the handout is available to everyone who has attended. And it's been very nice presenting this to you. I shall say thank you and good evening.